All right. Thank you for staying with us. And the conversation, as we hinted earlier before that break, is about the Supreme Court clarification and a judgment given granting local government financial autonomy and a range of things was put into that particular judgment, and not just the finance aspect, but that the fact that the local government and the leadership is a creation of the law, and so it is an elective position for to anyone and for anyone that want to vie for the position of the chairmanship or chairperson, it was called at some point. But then that what we've seen over the years now from different state government and different state governors is the appointment of caretakers, to just run the administration of this local government. And the Supreme Court has found out that to say we have a law, we must stay with that, and that anyone, any local government will only henceforth be recognized by the law if actually it has elected, leaders. In this case, chairman or chairpersons. Chairman, let's just stay with chairman of local government, and other things were discussed. And then the situation. This morning it was reported in one of the dailies that 21 states, are running contrary of this particular arrangement, this particular provision of the law, rather, and more than 4,000 local government areas are affected, and they should fix up because this has to do with the law. But to clarify for us further, we are being joined by a law lecturer. He's an analyst and, of course, a lawyer from the University of Hull, Dr. Misbau Lateef. He joins us from the UK. Good morning, sir. Thank you for joining us.
Yeah, good morning. I'm very pleased to join you.
Thank you very much. I called it a landmark judgment that was given by the Supreme Court. In that judgment that was read by Justice Hagbim, he said, I hold that the state retention of the local government fund is unconstitutional. Part of what the judgment, read. The minds of justice requires a progressive interpretation of the law. It is the position of this court that the Federation can pay local government allocations to the LGs directly or pay them through the state. In this case, since paying them through state has not worked, justice of this case demands that local government allocations from the Federation account should henceforth be paid directly to the LGs. This is part of just a section of that particular judgment. And Dr. Lateef, how did you receive the judgment of Milot at the Supreme Court? It is uhuru for you. Is it the right way to go? Is this something you have been looking forward to, or is it just one of those things?
All right. Let me start by saying that, and perhaps to paraphrase the title of the book of late Nelson Mandela, I think that judgment, gave us what you can call a long walk to freedom. And like you have also rightly described it, I think is truly a landmark decision of the Supreme Court. Before that judgment was rendered, I had some discussion with some colleague who actually thought it was impossible, and their argument was that there are specific provisions of the Constitution to the effect that the state shall maintain a state joint account and all of those. But then some of us, I'd argue at that time that, well, reading together various sections of the Constitution, it is likely that the Supreme Court would come to a conclusion that the local government deserve to reserve their fund directly. So alas, when the Supreme Court eventually came to that conclusion, it was quite, I would say, exciting to many of us. And I felt so excited the whole day because, like I said earlier, it has been a very long walk to freedom. And I think it is indeed a great leap in our democratic move, particularly for development of governance at the grassroots, for progress, at the grassroots, for effective governance, if you ask me. Because what we have seen over the years, unfortunately, and particularly since 2001, was a situation where the governors, they turned themselves to overlord. Well, I'm not saying all of that I'm not saying we have solved all of the problem.
Yeah.
So I will not say it is yet uhuru, but then it is a right step in the right direction, knowing full well that progress can sometimes be, or come at piecemeal. And gradually, I believe, having won this particular grant, the next grant and the next grant and the next grant would also, be eventually won. But this is actually a very landmark judgment, and I think it has, in a way, emancipated the local government. Whatever it is worth, we now have some assurances. For example, you could see this way some states are now falling upon one another in a manner of speech, trying to conduct, local government elections, even though we have seen some of the results in Adamawa and I think in Delta also, where the old, practice has been sustained. But nevertheless, this particular judgment, I believe, will galvanize people at the communities, at the local government council areas, to be more interested in governance at those levels,
All right.
rather than focusing on state capitals or the FCT Abuja, where the presidency is. So I think it's a very good judgment, and I think the Supreme Court has decided according to law. But I must add this caution. Please permit me to say it. I've not read the exact text of the judgment, and by training, we are taught, not to dwell so much in terms of analysis on specific terms of a judgment that we have not seen or read. As I speak to you now, I can confirm that the judgment has not been released. It is not yet in the public domain, so we cannot really see how the justices, arrive at that conclusion.
Right.
But at least we know what the conclusion is for
Yes.
now. So the ground or the basis, we'll find out later. But I agree with the conclusion. However they arrive at it, I think I agree with the conclusion.
All right. And fair enough. By the way, for the proper and the right context, that particular lawsuit was filed by the Attorney General of the Federation, Lateef SAN, on behalf of the federal government, seeking it to grant full autonomy and direct funding to all 774 local government councils in the area. And the AGF in that suit predicated it on 27 grounds. And he urged the APS court to issue an order prohibiting state governments from unilateral, arbitrary, and unlawful dissolution of democratically elected local government leaders. And the federal government further contended that Nigeria as a federation is a creation of the 1999 Constitution, with the president as the head of the federal executive arm of the federation has sworn to uphold and give effect to the provisions of the Constitution. And the conclusion, just like Dr. Lateef said, it was has to do with Justice Agbi saying that I hold the plaintiff's request is hereby approved and all the reliefs granted. By the way, it's fair enough to say you have not really seen maybe the CTC and the detail of that particular judgment. With the document, with what we have, sorry, I retrieved that, but with the information that we have, it has said that yes, finally, the 774 local governments have their full financial autonomy now, and we have been seeing reactions. And it was said again that no state government should henceforth appoint caretaker committees. They don't have the right to even dissolve, democratically elected chairmen as well. Ends. So, Doctor, beyond the financial autonomy, let's talk about this issue of state governance, unilaterally, arbitrarily, especially when they are not of the same party. Sometimes when they are of the same party, they can just come, disband, and, appoint caretaker committees. But the judgment, with what we have now, is saying you don't have the power to do that again. And just like you said, many state governments, have organized or have been trying to organize elections, albeit either is legal or not legal, either it follows the right way or it don't follow the right way, is another kettle of fish. Just like you said, Delta had his own at the weekend, and there was skirmishes and complaints, but that is on one side. But how significant is this, that no state governor henceforth has the power to disband, to dissolve any democratically elected chairman or chairman of any local government in his state, and that they don't have the power to put that arrangement that we'll call the caretaker committee? How significant is that?
All right, thank you. Let me quickly speak to, the nature of governance that the Constitution of Nigeria anticipates or prescribe at our local government council area. Now, Section 7 of the 1999 Constitution has always been very clear, and I can paraphrase that, where it says the system or a system of democratically elected official is hereby guaranteed at the local government. So the law has really been clear, from 1999, I would say. But unfortunately, our governors over the years have found a way around observing that provision of the Constitution in breaches by using your word, and I agree with that, arbitrarily unpicking and imposing, their friends, family, cronies, and all of that, people they could easily exercise control over. And the reason for this is simple. It is for power and resources. The governors want to have all of the powers, and then they want to control all of the resources. Now, what they have achieved with that over the years, is what the Supreme Court, I believe, has now, tried to correct by the judgment they delivered last week. Previously, there had been another judgment relay where the same court declared that the system of caretaker practice or whatever at the local government is unconstitutional. But then the governors have always, as I said earlier, found a way around observing that law in breaches. So what happened last week was briefly, if you ask me, a restatement of that law. And I think the point has now been made stronger that henceforth, going forward, hopefully so, no state shall be entitled, or no local government rather, shall be entitled to receive allocation from the federal or federation account unless they have democratically elected persons at their local government council. So it is very significant, therefore, as I said earlier, in galvanizing our people, in encouraging them, in stimulating them. Now that people know that the resources to run the local government is located within the local government, in that they will receive their fund directly, I believe that will encourage many people who had previously not shown interest at local government to now come forward and present themselves. And of course, because this is just a transitioning period, I mean, the Supreme Court just delivered the judgment a few days back, and then the governors who have been used to a particular way of doing things, it may take us time, before we transition to, I would say, some benefit of this fund allocation. But I can tell you that things can only get better going forward from here. Because as I said earlier, people can now focus. I grew up in a community in Osun State, and I could remember very well that in that community, our local government council area used to be a very beehive of activities, where you see people literally, go to council area, and you see construction works up and down, going on at the local community. I grew up in my community in Osun State, Ifon Osun, if you allow me to say that, with street light provided by my local government. And I remember that at the evening time, during particular season in the year, we will go below those street lights, as children, play under those street lights. Now, those were the days when local government had control over their resources, when people focus on governance at the local level where the people reside, where the farming, takes place, where the real activities of governance, where the real people live. The people, there are no people in the state, in a manner of speech, in the sense that everybody belongs to a family, everybody belongs to a community. So people merely gather at the state, the state is like a hub, to accommodate people from different places. You could say it belongs to everybody, and maybe nobody in particular. The same thing applied to Abuja or the FCT. So in the final analysis, the people reside at the grassroots. The people reside in their community. They belong somewhere. And unfortunately, over the years, the governors in Nigeria, they have deprived this community of progress, of development, in the sense that same community that I mentioned, I give just a practical example for your viewers. And I'm saying this as a matter of fact. On papers, my local government in Osun State receives an average of 250 million naira per month from federal allocation on papers. But ask me what goes to that local government every month: 12 million naira, 11 million naira. This is what I'm aware of. And what do the governors, and this is not peculiar to Osun State government, let me be fair with to the governor, this is what governors all over do. But I'm just giving you a specific example that I have, at least I can assert this. Now, my local government gets average of 11, 10 million every month out of 250, 300 million naira. Now, because why? The state claim they expend the money on their behalf. They claim they help them pay their personnel or officials or employee. They claim they do road for them. They claim they do all sorts of things for them. But what they actually do, in fact, is to siphon this money or to misappropriate the money for projects in other communities. So in the long run, the community who originally owned these resources, they don't get any benefit. The street light that I grew up seeing in my community in Ifan, they are no longer there. The roads, they are no longer there. The cover, they are no longer there. Things have gone, very bad, and it is not peculiar again to Osun State. This is what has happened over the years. And I think now that the resources are going back to where they belong, hopefully, now that power goes with resources anyway. When you are resourceful, when you have resources in terms of funding, for example, you tend to also be powerful. So now that people know that the resources are now located in the local government, credible people, I think, or I suppose, will show interest, and hopefully we will see more impact of government at the grassroots. There will be less focus or attention on the state capital or even Abuja, as the case may be. You will see a professor, for example, probably aspiring to become a chairman of a local government, just to make impact, to show people what they can do with their expertise or capacity and all of that. So I think, it is a very significant milestone. It is worthy of celebration. I think this is why, if you look around the country and even beyond, there have been more about celebration than, a few people who have come out to actually condemn the judgment. It has been an uproar of support, from my own personal assessment. So I think in our democratic journey for progress and real development at the grassroots, this is a very significant milestone for us.
All right, Dr. Lateef, talking about that judgment, which some people have called emancipation of the local government. Some call it the local government empowerment. A lot of terminologies used for that judgment. You spoke about the fact that from your end, it has been more of celebration and praises from people on that particular judgment from the Supreme Court. Now, let's talk about the controversies trailing this judgment and some condemnations from some quarters. With this judgment, then, does this judgment not invalidate Section 162 of the Constitution, which gives room for allocation to be paid into a joint state-local government account, and for the state government to pay the local government? Does this mean that the 774 local government chairmen will have to go to Abuja every month to collect their funds? And also, the Constitution recognized the federal government and the states, which is the federating units. How do we bring in the local governments into this? Does this judgment of the Supreme Court not suppress some parts of the Constitution?
Well, Section 162 that you reference, and I would say correctly, talks about public revenue. Now, the dominant aspect of that revenue is what the Constitution describes as federation accounts. Now, if you go to Section 162 sub 3 specifically, and that is the starting point for this purpose, it says the amount standing to the credit of the federation account shall be distributed among the federal government, state government, and local government. So now that opening provision anticipates that this fund in the federation account belong to these three tiers of government. Then I agree with you. It goes further, section 165, 166, then saying that the amount standing to the credit of the local government shall be allocated. Now, in the first instance, in section 162 sub 3, it says distributed. The amount will be distributed to these three tiers of government. But in section 162.5, it says shall be allocated. That is, the amount due to local government shall be allocated to the state. It didn't use the word distributed as it used earlier. For me, really, though I've not seen the judgment of the Supreme Court, but I want to think that, you see, in interpreting the law, that's what we call canons of interpretations. The Supreme Court or the court generally, they tend to look at certain principle to interpret what the law is or what the law means. Now, one of the most common, way of interpreting the law is what we call the literal rule, where you just simply focus on the literal text of the law. Now, sometimes the literal text of the law may not achieve the objective of the lawmakers. So if you ask me, if you follow the section that says the fund for local government shall be paid into a state joint account. Yeah. That's section 162.5, I think. Yeah. Okay, fine. You could say, why does the federal government therefore want to pay directly to the LG? So you could say there is a contradiction. Exactly. But if you compare that section with the earlier one, which says it shall be distributed to local government, you could see a conflict. Now, where you see a conflict like that, the court has a power to do what we call apply a purposive rule. A purposive rule says that you look at what is a fair situation in this case, what will serve the purpose of justice, what will be fair to all parties, what will help us to remove a particular mischief. Now, in this case, the Constitution, we have identified a mischief, and that mischief is that the governors have always found a way of circumventing the law. The governors have always abused these joint accounts. Now, the Supreme Court, as a court of policy, has that constitutional role to apply what I call a purposive canon of interpretation, which looks at the purpose of a law. Now, what is the purpose in this case? The purpose is that the local government should have their money. The purpose is that the money is for the benefit of the local government. So if we follow the simple literal text, which says you should give it to the state, and then we have found out that the state don't actually give the local government their money, then the courts have the power to apply a purposive rule, look at all the provisions of the Constitution, try to find out what is the intention of the lawmaker. What does the law actually seek to achieve? So if what the law seeks to achieve is that the governor should have the money and use it however they like, so be it. But if the objective is that the local government should have their fund and use it for their own development, and this is not happening, so the court has a power, and they have always done that in many cases, to apply what I call purposive rule to achieve the real objective of the law. So in summary, the courts sometimes don't always follow the literal interpretation of the law. We are doing so will not actually achieve justice. We are doing so will not bring fairness. So having said that, on the issue of federalism, I think people have made too much noise, with due respect, about this being something against federalism or what. It is not. In other federations like Canada, Canada runs a federal system. The US runs a federal system. India runs a federal system. In all of these federations, they also have, similitude of our own local government council. And they have instances, for example, in the US, where the federal government literally intervene to disburse funds to the counties, to the municipals in the US. In the same thing in Canada, the same thing in India. So mere direct allocation of funds from the federal government to a local government in a federation, in my opinion, does not necessarily violate the principle of federalism. And as I said, the example from other countries shows that federal government do have direct interaction with the local government, even in the federation. So I think it is very important that we, make this point clear. The mischief that has persisted over the years is what the Supreme Court has just helped us to, I would say, remove. And this is why people have said this is a landmark judgment. You've used the word emancipation, Evelyn, and you are very correct. So people think, and I agree with them, this has really, in a way, emancipated the local government. Now, we've won one track, in the battle. The next line, then you can move on to it, which is to, in my view, ensure that elections at the local government are credible.
All right, Dr. Lateef, we'll crave your indulgence. We'd like to go for a break now. When we return, the conversation on this Supreme Court judgment on local government autonomy, financial autonomy, will continue. Stay with us.